plan, a twisted little game. Jorge never saw it coming, but she knew just the same. In the darkness of the night, with a smile so sly, she whispered, "Let's play a game," and he didn't ask why. She zipped him up tight in the suitcase of love. No air, no light, just the stars above. He thought it was a joke, just a lover's embrace. Sarah, he cried in that tight, dark space. Jorge was laughing, but his breath was thin. The walls were closing in as the fear kicked in. He called out her name, but it echoed in vain, while Sarah watched coldly, not a hint of pain. She zipped him up tight in the suitcase of love. No air, no light, just the stars above. He thought it was a joke, just a lover's embrace. Sarah, he cried in that tight, dark space. Love's a game of risk, a dangerous thing. In the suitcase of love, it's a deadly flame. Sarah's smile fades as the silence grows. In the suitcase of love, nobody knows. Morning came with silence, no breath to be found. Sarah unzipped the case, Jorge's last sound. She stared at the scene. What had she done? In the suitcase of love, there's no place to run. She zipped him up tight in the suitcase of love. No air, no light, just the stars above. He thought it was a joke, just a lover's embrace. Sarah, he cried in that tight, dark space. Love's a game of risk, a dangerous thing. In the suitcase of love, it's a deadly flame. Sarah's smile fades as the silence grows. In the suitcase of love, nobody knows. Love's a game of risk, a dangerous thing. In the suitcase of love, it's a deadly fling. Sarah's smile fades as the silence grows. In the suitcase of love, nobody knows.
Hey, good morning, good afternoon, good evening, good night, everybody. How are we doing today? I hope everybody is happy and well and taken care of, especially those of you in the southeast corner of the United States. You had a rough night, a rough couple days, actually. I hope everybody made it through safe and sound. But there's only one way we can start this show today, people. There's only one way. We got to bring the lights down a little bit. And we have to wish a happy birthday to Sarah Boone. Happy birthday to you. Happy birthday to you. Happy birthday, Sarah Boone. Happy birthday to you. I hope you get all the justice you deserve for your birthday. Happy birthday, Sarah. I'll blow that up for you. You're in jail. You can't do that, so I'll do it for you. All right, let me fix my lighting here. It's Sarah Boone's birthday today. She is a spry 47-year-old. She's not going to be able to go out for a nice dinner. She'll get whatever slop they feed her in the jail. Tough. Right. Well, we're not going to do a little intro today. We're going to kind of jump into this, but we have a lot of stuff to talk about first. Yesterday we watched, I'm probably really, really loud. I am so sorry. I was on Nicholas's stream last night, on Nick Starrow's stream last night, and he messed with my volume severely there. That's back down where it should be. That looks like a sandwich. mean, it looks like a sandwich. That is a strawberry crepe cake. That is an amazing, wonderful strawberry crepe cake sandwich, you uncultured person. Yeah, so to kick things off with the unimportant stuff first, hi. Today, ladies and gentlemen, boys and girls, children of all ages, sad they can't say that at Disneyland anymore because political correctness, but anyway, today is day 31 of the emotional support potato pig dog cam. Will we make it to day 32? Are we going to keep the streak alive? Are we going to keep it there? The emotional support potato pig dogs are locked and loaded right here, just waiting to see if they're going to be able to make an appearance tonight, and that's entirely up to you. We unlock the emotional support potato pig dog cam at the 100 mark. Then there's super chats, gifted donations, purchased memberships, whatever. That's when we unlock the emotional support potato pig dog. Just my way of saying thanks to you for the support. And it's a little thing we got going for 31 days. So let's see where we go today. It's all entirely up to you, good folks. Today, we're doing part 2 of the hearing that we started yesterday. It's good that we kind of do these on a delay, especially since how the trial is being delayed, because that allows us to stop and talk about things a little bit more. So we don't just have to plow through a 2.5-hour hearing without many comments. So we'll be doing more of the same today, making some of the comments, stopping and talking about it, not stalking about it, stopping and talking about it, sharing some ideas. And tomorrow we'll be looking at some documents. There's some more motions that have been filed. There's some older motions to look at, and we might get going and look at some of the older cam footage. And then on Monday, we're going to go back to the very beginning, because that's a very good place to start. Julie Andrews told me so. And we'll look at the original indictment. We'll look at the original complaint and see what that is, and sort of get us a good launching pad into the hearing. Monday, with the jury will reconvene to the court will reconvene to select the juror. Again, as I've been saying the past couple of days, the way I understood it last time he announced anything about it was they're going to whittle the jury pool down to 50 potential jurors. Then they will take care of these final motions that they've got to get through before trial starts. And once the motions are ruled on and everything is settled down, they will bring the 50 jurors back in and make the final selection of the jurors who will sit for the trial, as well as the alternates. And then they will begin with opening statements. So I'm expecting the hearings on the motions to be streamed, but not the actual jury selection. So there'll be a couple of days maybe where we have something coming live from the courtroom next week, and there'll be a couple of days where it's just us trying to figure out what to do while we wait for the opening statements to start. And then once it gets going, we got about a 3-week trial ahead of us. So hopefully this will finish up right around Halloween time. And we've got our like and subscribe poll set up. Oh, but before we get to talking about the like and subscribe poll, Hey Joe has just gifted 5 Legal Vices memberships for releasing the hounds, and that was the wrong button. At least it's better than the wrong button I hit yesterday. This is the button we wanted. Hey Joe has gifted 5 Legal Vices memberships, and if you happen to be Tiffany, Boober, Daryl Smith, Amy T, Jensen, you are the lucky 5 people that got the gifted membership from Hey Joe. And make sure you give her a super special thanks. We'll be having our members only stream in probably 2 weeks from this Saturday or Sunday. So stay tuned for that. And that puts us 25%, 1/4 of the way to emotional support potato pig dog cam time. Thank you so much, Hey Joe, for putting us well down the road to day 32 of keeping the streak alive. And we have our like and subscribe poll set up, which is just a little poll to remind you to hit the like and subscribe button while we're doing this. We got 332 people here now, 165 likes. So please do me that super solid favor. And while we're doing this, we're going to be hitting the hearing in about 1 minute. So during this last minute, please reach down there and hit that like button. And if you haven't already subscribed, I would ask you to please do so. We are currently sitting at 80,000 804 subscribers. You guys got me over the 80,800 mark last night while I was asleep. I appreciate that so much. We're now 196 subscribers away from 81,000 subscribers. And it's all because of each and every one of you watching that have hit that subscribe button. And of course, all of you watching that will now hit the subscribe button. Thank you so much, guys. So our like and subscribe poll, which is just to remind you to do that, is what do you think? It's kind of serious today. Normally we try to have a little bit of fun with it, inject a little humor into it, but they're a little bit serious today. What do you think of the relationship between George and Sarah? Sarah was the only battered party. That's going to be the defense we're going to hear about today, is the battered spouse defense. She was the only battered party. George was the only battered party, or there was some give and take. There was some back and forth between the two. Those are our three. There's really not a lot of other options to that poll. So there's a blank option, which 10% of you have chosen so far. 10% of you have chosen the blank option. All right. Hit that. We'll check it back in an hour or so and see how that goes. And as always, if any super chats or gifted memberships or purchase memberships come up, we'll read them as quickly as possible. And they're not required, not begged for, not shilled for, but it does guarantee that, whatever you have to say, the super chats at least, whatever you have to say will get read, addressed, answered, whatever, acknowledged. And I'll do my best to talk about other stuff that's going on in chat that I find particularly relevant or interesting. Until something like that happens, let's get on with part 2 of the hearing, which deals with the battered spouse argument. Now, to begin with that, we have one document to read. We have one document to read. Where is our other document to read? It would be document number 29, I believe. And lots of documents here. There we go. Oh, hey. Before we do that, Kurt dropping the $5, getting us down the road to the emotional support potato pig dog cam. Still want to co-stream Sarah Boone. We talked about doing so long ago, but I'm still down if you want to roll together. Love you. Wow. That would have been when I had a better schedule a couple of weeks ago. But unfortunately, I'm going to be doing it delayed and a little bit faster and sped up. It's an awkward thing I've got with the time change going on and across the world and my work schedule. So I've got to stagger it a little bit. So it's gonna be difficult. So yeah, we'll definitely have to at least skip one day next week. So yeah, there's more trials down the road. But thank you so much, Kurt. This thing should have happened a year ago, back when life was simple. But getting on 81,000 subscribers, coming for you, Kurt. I'm on your heels. I'm on your coattails. Matilda, and all the way from the Netherlands, says hello from the Netherlands. Easy, buddy. Check Zelle, says making law simple. Hey. Zelle. Ooh, Zelle is nice because that's a straight in there. Let's do this, shall we? Let's see what we got going for messages there. Excuse me. Pausing whilst checking Zelle. Signing in. That's one that we have to dust off. All right. Logging in. Something's happening. It's taking its own sweet time. Well, while that's oh, there we go. Let's see. Wow. All right, making law simple, MLS. What? No, dude. Okay. Timeout. Timeout. MLS. Did you put an extra 0 in there? I'm honest to God asking that. because MLS making law simple just put $350 into the Zelle. Wow. I'm waiting to see if was that supposed to be a $35 thing? Because I'm a little bit stunned by that. No, I'm okay. Well, that's the signal. All right. Well, for that you get 3 foghorns. 1, 2, and 3. Making law simple. Easy buddy check Zelle dropping $350. Wow. Well, jeepers. All right, I'm a little bit stunned by that. Got to admit, a little bit shocked and stunned. So hey, give me a second here to regroup, pull my head out of my ass, and read a couple things. Jedi Jess added a list of potential witnesses to the Google folder based on past depots and subpoenas. Thank you very much. We will definitely check that out. Thank you very much, as they say over here. Little bit stunned, I must say. So emotional support potato pig dog cam, and that was just blown out of the water, straight out of the water right there. So I apologize to people that are joining. I expected to be, I just kind of got way thrown off. There we go. That goes away. Holy crap. And let's see, we can remove this and we can, where are they? Where did they go? The emotional support potato pig dogs. Where are they? Yoda was freaking out, wondering what all that was about. So Yoda is mobile. So getting us straight out of the gate today with the ridiculously large super chat of $350 plus the $2 to tell me there was a $350 self deposit, making law sample MLS, getting us to that point which we call
Release the hose.
And there is our emotional support potato pig dog of the moment, Strawberry. Yoda's out here in the hall. When Yoda comes back in, we'll switch the camera over. Wow, thank you ridiculously much. So pretty sure that calls for several things to happen. First is the absolute thank you shot of really good Japanese whiskey, the Hibiki Harmony. So delish. Thank you from the bottom of my cold, crusty old heart. Thank you very much for that. Deeply appreciated. Yum. And now a little bit later, not too far down the road, we will do the second tier, which is a shot of really bad whiskey. We'll explain at a break in the trial just a few minutes down the road. And that also got us to our third tier, which is a double shot of absinthe straight, which will probably be to in about a half hour. Got to work early in the morning, but wow. So don't let me forget that I'm 2 down. So thank you very much, everybody. That was a little bit of a surprise there. God. All right. Heck. See, you got me so befuddled I can't even curse right. Heck. Let's go. Buddha Berries with the Aussie 5. I think that's let's go. Yes. He might have tapped out the main on meme stream. Yes. Yes, that is who it is. Shh. Yes, that is the man, the legend himself. Right. So, present screen. This is the motion we need to look at right here. And let's see, we can stretch it out a bit and embiggen it so we can see better at home. This is the notice of intent to rely on the defense of battered spouse syndrome. This was filed on September 6th at 10:22 and 44 seconds. Comes now the defendant. I'm sorry, you got to take a deep breath and say the magic words. These are the magic legal words. Wait a minute, I have hidden the magic. There we go. I'm still kind of a little bit taken aback by that. All right, here we go. Say the magic words, everybody. Comes now the defendant by and through the undersigned attorney under Rule 3.201 battered spouse syndrome defense of the Federal Rules of Criminal Procedure, given notice of intent to rely on defense of battered spouse syndrome and states. Ding, 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 ding. Sprinkle water, incense. All right, there we go. We got the magic words out of the way. The battered spouse syndrome. At the time of the alleged offense, so this is the notice from the defense that they are going to be relying on the battered spouse syndrome defense. At the time of the alleged offense, the defendant was suffering from battered woman syndrome. I wonder if we can get battered man syndrome. Is that a thing? Is that a thing? But anyway, the defendant was suffering from battered woman syndrome as a result of the physical and psychological abuse the defendant sustained at the hands of the alleged victim, George Torres. Again, spelled Jorge, but everybody pronounces it George, so that's what we do. Dr. Julie Harper will be a Category A witness for the defense in establishing this condition on behalf of the defendant. So we're relying on the battered woman syndrome, and this is our expert that's going to testify to it. Dr. Julie Harper, forensic psychologist, Northwest Florida Psychological Services, 1992. Lewis, we are not going to read that anymore. YouTube doesn't like that. Go away. I now certify that I electronically filed this. Go away. No, go away. There we go. They don't like it when you put any type of anything that resembles an address out there. So go away. Bruni Saint with the 5 Australian. We got a lot of Aussies here. It's late for you guys. Well, if you're on the East Coast, then it's just normal if you're on anywhere else. Looks like Strawberry was hoping for some whiskey too. She sat straight up at the uncorking. Oh, they might drink the little droplets that fall on the floor occasionally. And they all like cigar smoke too. They both like cigar smoke. Thank you so much for that, Bruni Saint. Right. Well, heck, let's get it out of the way right now. For those of you that know, when we get to the second achievement, which is the 200 mark, we try to get rid of a really, really, really bad whiskey that I have. So we are attempting desperately to get rid of the Kirkland. That's the Costco brand, the Kirkland blended Scotch whiskey that I've had for about 6 years because it's just darn near paint thinner and undrinkable. So because people accuse me of keeping my dogs behind a paywall, which I don't, I reward you with them. But people decided that I need to have a punishment for doing so, which is this. Oh God, I can't wait till that bottle's gone. Ugh. All right. Well, we can wash that down one way with the official Sarah Boone cocktail. This is the Boone Tang Suitcase Cocktail, the official cocktail of the Sarah Boone trial. Vodka and Tang drunk over ice. I've downsized from a 1 liter to a 500 milliliter cup because I wake up like 4 times to go to the bathroom. So this is the Boone Tang Suitcase Cocktail. There we go. Great success. No, it's not a 2 liter bottle. It's a 1.75 liter vodka bottle. All right. Let's hear more about this battered spouse defense, shall we? Because that's what the remainder of the hearing is about. So we're going to bring that up. We're going to embiggen it, and we are going to hit the road. So strap in, people. Now we get to hear more about the intention to rely upon the battered spouse syndrome defense. The battered woman.
And I'll leave it up to you, Mr. Owens, to do what you need to do in order to have that review.
All right,
we got.
I'm gonna do my best.
These things.
We got about 18 days.
This is a little bit of an overlap from what we did
cite
yesterday.
to the parties for their own benefit There were motions, specifically defendant's motion to appoint an electronic evidence
All right,
wiki, and there was
We can fast forward through
intent
this.
to rely on the defense
There we
of
go.
battered spouse syndrome.
Let's go.
The original notice was filed September 6th. The state's original motion to strike.
That's what we just read. Was the September 6th document he was just talking about.
The original notice was filed September 6th. The state's original motion to strike was filed September 9.
Just to interrupt, I also have this defendant's motion for enlargement of time to address as well.
Yeah, I have that on my list, sir.
Okay.
Thank you. Thereafter, on the 15th, an amended notice of intent to rely on the defense of battered spouse syndrome was filed. On September 13th, the defense's response to the state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome was filed. And then I think it was this afternoon. Earlier today, the state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome was filed. The court has reviewed those and all of the citations contained therein. Mr. Owens, you may proceed, sir.
Judge, I wanted to start my argument, and then Mr. Henderson, who is on the screen, is going to respond to the state's pleading that they filed this afternoon.
Mr. J, you have any problem with that?
I know there's a rule in the circuit about one witness per one attorney. I don't know what the administrative rule says about arguments. I leave it to the discretion of court.
Okay.
He's arguing that one motion that they filed this afternoon that I've been working on these. He was working on that motion, so it's a separate motion.
The motion to strike.
The last motion whatever motion they filed today, Mr. Henderson, Tony Henderson here in the screen wants to respond to that. I'm
Okay.
going to respond to the ones that were filed prior to today.
All right, I'll allow it. All right, go ahead, sir.
Judge, as you know, I filed my notice of appearance on August the 30th, I think 38 days prior to trial, knowing that the court had already made a ruling that you would not grant a continuance unless there was some type of exceptional circumstance. And Sarah Boone hiring or retaining or somebody pro bono coming on the case and representing her did not constitute exceptional circumstance.
No, it didn't. It really wasn't exceptional that she appointed somebody. She's done it 8 times, some of which begged to be let off, others conflicted out. But yeah, it's actually quite common for her to appoint counsel in this case. And I also have a delicious old fashioned here because reasons. So we'll be sampling from various items tonight. Let's hear how this goes.
And so, as you know, we had the hearing after I'd filed the notice on August 30th. We had the hearing on September 3rd on my motion to continue. The court denied it. At that time, I explained to the court that I believed after my meetings, I think I'd had 4 with Ms. Boone, that she met the criteria for battered woman syndrome, but that I needed an expert. And we were vetting several experts at the time, 4 or 5 that we were vetting, and we needed more time to essentially pick somebody to go out and do an evaluation, an assessment of Ms. Boone to determine whether or not they would give an opinion that she suffered from that. Because, and I understand, the court denied our motion, so that left us with, we still had to give notice to the state attorney 30 days prior to trial of October 7, which I believe was going to be September 7, which fell on a weekend, which was that Saturday, I believe. So we got out of the hearing. I think the hearing was on a Tuesday. We had 4 or 5 days to file this notice, timely file the notice. So looking at the file, I realized that Dr. Harper had the most time with Sarah Boone. Early on in the case, I think when Mr. Padilla was handling the case, she was appointed by the court to do an assessment and evaluation. And so I reached out to her, and she agreed to come down a couple of days after we had that hearing, and she met with and assessed Ms. Boone. I've retrieved all the notes, the prior notes, and then the notes from that meeting. And then on Friday, I spoke with her, that Friday, which I believe was the date that I filed this notice, September the 6th. That Friday, I spoke with her on the phone and immediately went down and filed the notice of intent to rely on the defense of battered spouse syndrome. We made allegations that Dr. Harper had formed the opinion that at the time of this offense, that Sarah Boone was suffering from battered spouse syndrome. And at that time, we gave the name of Dr. Julie Harper and her address where she could be found and located. And of course, the state has set her deposition for October 1. Now, the state has filed a motion to strike the notice of intent, alleging that we didn't give sufficient facts or evidence. But Judge, realized at the time, I was simply trying to get it filed because the last day was the next day, Saturday. And of course, I had
You did
just
good
gotten
with what you could
discovery.
do, brother.
Judge Creighton, we have not finished reviewing all the discovery in this case. I pretty much shut my law practice down to try to do it. I've gotten my staff, and we're trying diligently to go through all the discovery. At the same time, we realize that we've got to establish corroboration of the battered spouse syndrome from eyewitnesses, from medical records, from potentially neighbors, court records, her phone and the information on phone. So we're diligently trying, number one, to review all the discovery, which still has not been done. At the same time, trying to locate additional evidence that we could utilize in helping to establish the battered spouse syndrome. In addition, the state attorney yesterday filed a notice that they're amending their discovery, and all the jail phone calls, or I think they have the ability not only to call, but they have a tablet and they can text back and forth with third parties, that they have disclosed that they have, I guess, 4.5 years worth of communications between Sarah Boone and parties on the outside.
Well, yes, they have 4.5 years of communications, as Porcelain Thunder said, because she's had years to do this. Years, 4.5 years to get her shit together. So, there we go. And that's what the judge told him. You know what you're walking into. You know the time frame you're walking into. If you want to do it, do it. If not, no harm, no foul. Lego Lisa says, ever try a Fireball old fashioned? They are big over in Wisconsin. So yummy. Oh, say, Lisa, Lego Lisa, step your game up. Ooh. Oh no. Oh no. I think I told my Fireball story on the Lego stream recently, and I can't stand the sight of Fireball. Just real quick, just chat, humor me, all 563 of you, humor me for my little ADHD rant here. I used to think Fireball was okay. Then a friend of mine and we got this really good idea that after this baseball game, we would go to our friend's bar and we should each consume a bottle of Fireball, which we proceeded to do. It was so, it's just cinnamon flavored syrup. Blech. And I ingested probably 8 million calories from that one bottle, and 2, I got so sick. The sugar plus the alcohol plus the dehydration plus just the sickly syrupy sweetness of it. I can't even look at Fireball anymore. I'll put like 1 or 2 shots in some eggnog around Christmas time to give it that little spicy cinnamony flavor. But no, Fireball old fashioned is never going to touch my lips. And Daily Quick Buy says, Legal Vice, good day, Jeff boy. I'm curious as to the cause of death. That thing doesn't look airtight. Well, stick with us because tomorrow we are going to be reading the autopsy report. So your question will be answered tomorrow. Hate to keep you hanging, but tune in tomorrow for, among other things, the autopsy report. And Lego Lisa Squid Pro. That's what I usually drink. The bartender told me about Fireball and I'm hooked. Ugh. Good for you. Good for you. If we get 500 likes, Jeff will get 505 more drinks. No, we get 500 likes every day. I haven't even done. Oh, let's just go. And I'm gonna take care of the third one, the absinthe. We're gonna go with the absinthe. This is the third tier that's been unlocked. So, cheers. Try absinthe. Real absinthe is so much better than Fireball. All right. Oh no. Thanks, Lasco Brandon. All right, go.
And that some of that may be relevant to the case. And we were advised that when I got in town that I was to bring a CD. And I did this morning. I went to the state attorney's office and spoke with the secretary and explained to her that here's my CD. I'll wait. And I was willing to wait in the lobby to get this additional discovery when we have 19 days for trial. She told me that there was a lot, quite a bit of it, that she would try to get it to me after the hearing or by the time of the hearing. I said, okay. I left the CD. I told her she had my number. She could text me. I was staying at the Hilton across the street from the courthouse. As soon as she had it, I wanted it as soon as possible. A short time later, they have started, I guess, going through that material, and now they're sending discovery through email. I assume instead of the CD, they're going to do it that way. But we are receiving it. But just the volume of discovery that we have to begin with, we haven't gone through. The evidence we're trying to gather to corroborate our defense, and then additional discovery that we were noticed about yesterday. I didn't have time. I knew this had to be filed. I had one more day. As soon as Dr. Harper told me on that Friday, I knew I had until Saturday. I filed it. The state knew. They've had it 4.5 years. They prosecuted the victim in this case, George Torres, at least 3 times. I think there's more like 4 or 5 times. But they opened up a file. They prosecuted him here in this county for battery in violating the conditions of bond relating to staying away from Sarah. But battery.
Okay. Now he's starting to lay the foundation. He's starting to lay the groundwork for the battered woman syndrome defense, saying that George has been arrested, prosecuted 4 or 5 times for battery on Sarah Boone. And he's violated his probation or probation or parole with regard to staying away from her. So he's starting to lay the foundation that she was habitually and serially abused by George, which therefore somehow led her to uncontrollably zip him up in a suitcase and let him die. Well, as MG Law says, and she beat his ass too. It was mutual. Well, that's one of the like and subscribe choices, and I'm sure the prosecution will mention that as well. But let's continue. Great success. No, George is not pronounced Jorge. It's spelled Jorge, but he himself calls himself George. Sarah calls himself George. Everybody else calls him George. So who am I to argue that his name is pronounced George? So yes, it is George, not Jorge.
The conditions of bond relating to staying away from Sarah Boone, but battery on Sarah Boone. They, if anybody, was well aware that there was a potential problem with the habitual nature in which Mr. Torres beat on my client.
Hey, the Ramones
In
had a great
addition,
song, Beat on the Brat. With a
my
baseball
client
bat.
expressed in the interrogation, which I know the court hasn't seen, please look at the videotape. Please look at my phone. Please look at the videotape. Please look at the photographs. I need my phone to show you. He comes at me. It was ignored. They've had all this evidence. They had to be on notice that this was a potential issue. And the reason being is all the lawyers that have been through this have appointed different forensic psychologists to assess her. The prosecutor that's not here today, that was here on September 3rd, when I mentioned the problems that we were going to have, getting an expert this quickly to form an opinion, said, oh, no, Judge, we're not prejudiced. We've already got an expert. We intend to rebut any said opinion by an expert that she suffers from battered spouse. We're ready to go. We've got our expert. Such that they said, we don't even need a continuance. If, in fact, he finds somebody and they file something, a notice of intent to rely on battered women syndrome, within the time limits, we're ready to go. We don't need to continue it. We'll have our expert. And as you know, they're requesting that their expert now be allowed to go to the Orange County Jail and assess Ms. Boone, which they have every right to do, since we had filed this notice. But they indicated they would not be prejudiced. They indicated they were on notice. They didn't think it was going to happen 4.5 years, but it did. They knew all the prior abuse that Sarah Boone suffered at the hands of Mr. Torres. I did the best I could, Judge. I filed it. I felt like I had to have an expert. I explained in general terms that she was psychologically and physically abused by Mr. Torres repeatedly over a period of time that led to this event. They filed their objections, which we believe is misplaced. The court, as you know, by that rule, let me find it.
You should be prepared for this, sir. You should have this at your
It's
fingertips.
apparent not only that the state was on notice, that we were going to rely on it, it was prepared to respond and was not prejudiced in any way. The notice of intent to rely on the defensive battered spouse syndrome comports with the requirements outlined in 3.201, given the current circumstances of the case. And as you know from that rule, it says the notice shall contain a statement of particulars showing the nature of the defense the defendant expects to prove and the names and addresses of the witnesses by whom the defendant expects to show battered spouse syndrome, insofar as possible. Insofar as possible. I did the best I could, Judge. In addition, as soon as we started going through the discovery and gathering information about the prior events, the prior arrest of Mr. Torres, the prior prosecutions of Mr. Torres, we immediately amended the notice on September the 15th of intent to rely on the defense of battered spouse. And again, listed as many witnesses as we could based on the good faith belief that we had that corroborated either by witness testimony or physical evidence, photographs, videotapes, medical record, whatever we could find that would corroborate our defense. In addition, we've listed the ex-husband, Brian Boone, and the last paragraph, paragraph 14 says the defendant's investigation of evidence to support the defense of battered women syndrome is ongoing. The defense anticipates additional witnesses, photographs, videotape, medical records, court records, and other evidence gathered from the defendant's phone will be forthcoming. This evidence will be disclosed as it is discovered. Thank you.
Response, sir.
Wow, how would you guys respond to that? She wanted to show you on her phone the videos of him, doing things to her, coming at her, the broken stuff that she alleged. She kept telling you that he was out of control, kept telling you that he had anger problems, kept telling you that he was doing these things. He's been prosecuted 3 or 4 times for this type of thing. He's violated his probation and parole and probation for these things. How would you respond to that if you were the prosecution? It's an interesting thing, and I guess we've just got to lock in and see how the prosecution handles it, shall we? How would you respond to her own statement? His family thought I would kill him. That's a very good point for those of you that are paying attention to the body cam footage. On the initial body cam footage of the police arriving and talking to her about it, she did say on I think 2 separate occasions on that video that her family would kill her. His family would kill her because they didn't like her because she was a blue-eyed white devil, and they always said that they thought she would kill him. That is on the body cam footage. Because I have not watched this hearing. I am going into this blind. Most of you probably have more information about what's going to be coming out than I do. But that would be a good thing for the prosecution to bring up. So that's interesting. That's a very, very good comment. That's a very good response. How else would you guys respond to that? If you were the prosecution, I'd play a video of SB telling George how to get charges against her dropped. Oh, they have a video of that? See, this thing, I don't have a lot of this other video. I don't know where people got it or where people have it stored. But if you have any of the raw video, I want to try not to use other people's channel video as much as possible, because I never know how they're going to react. If I watch their video, they can either go, hey, thanks for the shout out, or they can go, I'm going to copyright strike you and get your channel removed. If I don't know people, I try not to use their videos. But so if anybody has any access or any links to body cam footage or interrogation video, or the, like the interviews with the neighbors, or this video of Sarah Boone telling George how to get, if you have any of that, please let me know how I can get a hold of it through a Twitter DM on @thelegalvices at x.com or whatever the hell it is. I just say Twitter. Make sure it's The Legal Vices and not just Legal Vices. If it's just Legal Vices, it'll get sent to a big black woman escort service and prawn video manufacturing company in Las Vegas. I didn't know that until after I had my channel name. But yeah, the Legal Vices, just Legal Vices, goes to this other place where the faint of heart fear to tread. And so The Legal Vices, just to send it to me on Twitter, send me links or information how I can get some of this stuff that you're talking about that I have not seen yet. So I would appreciate that. Thank you very, very much, Northwest, for doing that. Didn't they recommend experts she could hire and she wasn't personally allowed unfettered access to her phone? Yes, the prosecution actually went so far as to say, when she said, I want my phone back, they said, well, here's a guy, call this guy. His deal is he provides this data analysis service to indigent defendants, and he's done it before, so give him a call. And the call was never made. You would respond by everything that guy just said is BS.
Everything that guy just said is bullshit. Thank you.
Daily Quick Bites. Nope. See, you guys are like joking, I know, but you're the ones that are looking silly. It is George. It is George. Hey, whore. No, that's different than Jorge. Let's go. Let's see what the prosecution actually says on their own behalf.
The state is not surprised by any of the evidence that has been in the discovery for years. I'm not going to belabor the facts in the discovery, but suffice it to say that the decedent and the defendant had a violent relationship, and generally this violence seems to be fueled by alcohol. We're completely aware of all of this domestic violence history, but that does not make a battered spouse syndrome defense any more than being mentally ill without showing more makes for an insanity defense. Their original notice was insufficient, and there's no reason to argue it since they've amended it. So turning to the amended notice, it still does not set forth what they are going to show that shows that she suffered from battered spouse syndrome. Was the decedent isolating her from her family and friends? Was he telling her that if she ever leaves him, he'll kill her? We have these instances of violence between the two of them. And when we get referred to the ex-husband, Brian Boone's deposition and statement, what he reports is that Sarah Boone would attack him, scratch him, punch.
There you go. There you go. He's raising it here. He's raising it there in the chat. And that was something that was actually brought up during the police body cam. During the police interrogation at the sheriff's office. I guess they're sheriffs, not police. They're all police to me, but I know sheriffs get grumpy if you call them police and whatnot. but they're all this, they're at the law enforcement office. Because what they said was that they had conducted the autopsy, and let's see, where did we go? I have it written down. The interrogation said that I don't have it written down, but I thought I had it written down, but I don't. But to paraphrase, they said we did the autopsy and we found scratch marks on his back, scratch marks on his neck, a fat lip, and a couple of lumps on his noggin. So that was pointed out to her that stuff came up in the autopsy report. And there's speculation that she actually got him into the suitcase upstairs and sort of rolled him down the stairs. But we're going to look, as I mentioned earlier, in detail at the autopsy report on tomorrow's stream. So join me tomorrow to hear exactly what was found during the autopsy of George Torres.
Him in that she was a habitual alcoholic, and he would have to lay hands on her to restrain her. So we are going to potentially dive into all of this information in trial, but there are still the rules of evidence. And the cornerstone for the battered spouse syndrome defense, which is a misnomer under the case law, because self-defense is defense, and battered spouse syndrome evidence is relevant to help a jury understand why it's objectively reasonable for a battered spouse to stay in a situation that puts them in fear of continued violence. The state and wherein our confusion lies is nowhere in any of the witnesses or any of the discovery that they have listed, exhibits that they don't even have been listed, medical records and so on and so forth. Nowhere does it set forth this cornerstone that is absolutely necessary before we get into any of this battered spouse syndrome evidence, before we get into any potential reputation for violence evidence of the victim, before we get into any potential specific acts of violence by the victim, before we get into the rebuttal evidence that is going to be offered against her for her violent nature and her drinking. The cornerstone is self.
Now remember, when she was during the course from the body cam footage to the interrogation video to the hearing that she took part in last week, her story has changed so far. She has said all the things. She has literally given every answer that's possible to give in relation to alcohol. I don't drink. I didn't want to drink. I was not drunk. I was not drunk. I had a little bit of a hangover when the officers came, and I was still drunk when the officers came. And now, mind you, she has also said she had one. They had one bottle of wine, which he bought two that day. There's records showing he bought two that day. There was a little bit left in one bottle. So, well, they probably had about a bottle each, but we don't know what else they had. But she, according to her version of the story, they shared one bottle of wine. She went up to sleep. And this is her most recent version of the story. They had one bottle of wine. She accidentally went upstairs, accidentally went to sleep on him. Was presumed he had half a bottle and she had half a bottle of wine, 13%, 15%, somewhere in that neighborhood. She fell asleep around 12:30 a.m. She went upstairs about 12 a.m. So we'll give her the benefit of the doubt and say she stopped drinking at 12 a.m. The police showed up at 1:30, and according to her most recent testimony, she was still drunk and hungover. She was still drunk she slept 12 hours and was still drunk by the time they showed up. 12 and a half to 13 hours later. She's still drunk and befuddled on half a bottle of wine 13 hours after she stopped drinking. Any of you that have ever consumed an alcoholic beverage know that math does not math at all. But that's the story she's given. That's the story she's giving. And I like what he's saying here about her drinking being the cornerstone of problems. So he's going straight into this. She's saying, she also, I'm sorry, I forgot to mention, she also said at one point, I can't get drunk. So we've had, I didn't drink, I wasn't drunk, I can't get drunk, to I still had a hangover, to I was still a little bit drunk 13 hours after I stopped drinking. She said it all. Literally every nuance, every possibility of an answer you could give relating to alcohol consumption, she has given. And if you listen to if you listen to her phone video of her videoing him in the suitcase, she sounded drunk AF. She was slurring her words all over the place. I'm going to say there was more than half a bottle involved. I'm going to say there was more than one bottle involved. But let's see how he continues to make his argument. And while we're paused here, just want to mention we have exactly 700 viewers, but we only have 373 likes. We should have at least 700 likes at this point. So while in the next 10 seconds here, just flash down there and hit that like button and subscribe if you haven't already done so. We are working. We're less than 200 subscribers away from 81,000 subscribers. So pop on in there, hit the subscribe button. We are exactly 190 subscribers away from 81,000. And hit the like button, quick. And let's get on with this and hear what he's going to say about Sarah Boone, her battered woman syndrome defense, and her alcohol consumption.
Before we get into the rebuttal potential specific acts of violence by the victim, before we get into the rebuttal evidence that is going to be offered against her for her violent nature and her drinking, the cornerstone is self-defense. Her statement to the police is not one of self-defense. It is one of accident. She repeatedly says there was no violence that day. So that is where the state's position is, that their notice is deficient. It only sets forth that there has been violence between the two of them, and it's apparently exclusively alcohol related, but it doesn't.
That's interesting, saying that the only time they're violent is when they're drinking. There are some people that just should not drink, that go from, hey, let's have a drink, to haha, I'm feeling good, to let's fight. There are those people out there. And that's what they're saying. They're saying that he is saying they both only get involved in this sort of behavior when alcohol is involved.
And go on to say this violence has caused her to suffer from the syndrome. And here's why. She was afraid to go.
Oh, let's go. Brandon says, speaking of consumption, don't check Zelle. All right.
Meet with her family. She was afraid to leave. She was any of the things that make up what is actually battered spouse syndrome. And moreover, it doesn't set forth the self-defense claim, which is the cornerstone of this. None of this comes in without a claim of self-defense. And so that's in part why we filed our motion in limine with that response, is the court can and should not allow any mention of battered spouse syndrome come in until self-defense has been established at trial. And as far as I can tell, the only person that can set forth a self-defense claim, since it was just her and the decedent in the apartment that night, is her. So she'll need to testify, and then she'll be impeached unless there's a ruling that the statements that she made to the Orange County Sheriff's Office are not only a violation of Miranda, but are involuntary and unavailable for impeachment use. That's what we're hoping to avoid, because we can't unring the bell during trial. If they put on all of this testimony and evidence about battered spouse syndrome and about the past violence, and then we introduce evidence about her past violence against him and against Mr. Boone, it's hard to unring that bell. And even though King versus State, a 2000, I forget which year, 19 case, allows the state to point out the things that are promised in the defendant's opening statement, but then don't come to fruition, that doesn't unring the bell. So that's what we're.
Okay, that's also an interesting point he's making there. He's saying, I want to avoid a situation where they get on the they get her on the stand, and they talk about all of these times that he has consumed alcoholic beverages and proceeded to wail on her. And then we're going to get up and we're going to say, well, but also she was doing the same thing. And he's obviously concerned about victim blaming, how that's going to look like victim blaming to people. But also, once they hear that, he has done all of these things previously, you can't unhear that. Once the jury's heard it, you can't unhear it. So they want to make sure that we don't create a situation like that. And Endless 013 says, I think I can't get drunk doesn't mean physically I can't get drunk, but rather I'm a violent drunk. I can't get drunk. It would be, but I think it's the former. If you actually look at the interrogation video, the way she said it, she said, I can't get drunk. I wasn't drunk. I wasn't drunk. I was not drunk. It seemed to me she was saying that she just cannot get drunk. And she was blaming him for drinking, saying alcohol is BS. Alcohol is the problem. I can't get drunk. I wasn't drunk. I was not drunk. I was not. So I think she was saying at that one point, trying to justify it by saying, I didn't get drunk. I was not drunk. That's my take on it. And I appreciate your take on it. And, that's the beauty of the jury. One juror could hear it your way and another juror could hear it my way, which would lead to some very interesting discussions in a jury room, perhaps. And let's go, Brandon. Said, don't check Zelle. Let's go, Brandon has dropped another 200 in Zelle. So thank you very much for that. Let's go, Brandon. I'm gonna run down the hall to retrieve some good stuff, and I will be right back. Dang it, stop that. And I'll let this play while I'm gone. I'll be gone in like 20 seconds. Bye.
We're asking for sufficient notice. The statement of particulars that is required by the rule, where is it setting forth there is a self-defense claim, and then there is going to be this shown beyond just the past violence between the two of them. Thank you.
Judge, they're scheduled to take the deposition of Dr. Harper October 1, so they're gonna know fairly quickly what her opinion is.
What's your response to Wagner?
We're going to talk about Wagner, Judge, and I want to talk about that in a minute, but he's bleeding the argument into state's motion to strike the defendant's amended notice. And I would like for Mr. Henderson to respond to what he said about that. But Judge.
I agree. There's two different issues here. The first issue is the sufficiency of the notice, and whether the notice is sufficient under the rule. The second issue from the court's perspective, is it applicable? And that's the hang up that I'm having.
That's not to be decided today. That's not Wagner, whether it's an accident or whether it's battered spouse and there was self-defense. That's not to be addressed today or not to be decided today. That's going to be based on the testimony from Ms. Boone about what was going on. But I'd like Mr. Henderson, if you don't,
but that's not what Wagner stands for. Wagner didn't allow. Wagner struck after multiple amendments, and the court, and we can take judicial notice of it if you want to, the court has pulled the file from the trial court in Wagner and has looked at the notices that were filed in that case for the battered spouse defense.
Judge, ultimately, the female defendant in that case claimed that the firearm discharged accidentally.
Correct.
And the court ruled, hey, you can't have it both ways. It can't be an accident and at the same time be intentional that you committed as self-defense because you're.
Okay, the judge is on to them here. The judge is on to the defense. Absolutely an important point. Sarah is saying it was an accident. She didn't mean for him to die. It wasn't intentional. It wasn't intentional. It wasn't intentional. She said that so many times during her interrogations, during her questionings, that it wasn't intentional. I didn't mean for that. I didn't want that. You should know that. It was never meant to happen. It wasn't intentional. But now they're relying on the self-defense due to battered woman syndrome argument, where if you did it because it was self-defense, it wasn't an accident. So he's saying you got to choose your lane here, buddy. You can't argue on the one hand it wasn't intentional, it was an accident. I just accidentally fell asleep and he accidentally died on the one hand, and then on the other hand say I'm a battered woman and I was acting in self-defense. I really, really like this judge. He's a no nonsense, take no BS judge. He's holding everybody's feet to the fire. And this is a crucial part here. Let's go back and let this play through.
The firearm discharge accidentally.
Correct.
And the court ruled, hey, you can't have it both ways. It can't be an accident and at the same time be intentional that you committed as self-defense because you're a battered spouse.
Right. So how is battered? Even
It's premature for them to be arguing the question of intent.
but that's not what Wagner says. What Wagner specifically says, although the trial court found the third legally sufficient, the court granted the state's motion to strike the notice and precluded appellant from presenting the battered spouse syndrome evidence at trial. And the DCA says that the evidence underlying in that case was all accident. Specifically, the located.
That's them, not me.
Battered spouse syndrome as admissible where the defendant claims accident rather than self-defense.
We're not claiming accident.
Well, then what are you claiming?
Okay, that's a good thing. We're not claiming accident yet. Everything in her police interrogation video is, it wasn't intentional. I didn't intentionally do this. I didn't mean to do this. I didn't want this. That's literally everything she told the police after she's been read her Miranda rights it was unintentional. That was her big deal, was like, yeah, he's dead. And they even said at one point, you do realize that you were the cause of his death, right? She said, yeah, but it wasn't intentional. So he's saying we're not arguing it was an accident, but literally everything she's told the authorities up to this point was it's an accident. It was unintentional. So they've got a little bit of reconciliation to work out. They've got to figure out how to make this battered woman syndrome argument and incorporate all of her statements that she made after being given her Miranda rights that say it was an accident. And she also said he's doing so much better after, his counseling. I guess he had anger management or something. He's been doing so good after his counseling. He's been going to his meetings. He's been great. We were having so much fun that night. Everything was great. And it wasn't intentional. You've got to reconcile this with the arguments he's making here. And we owe the Let's Go Brandon the awesomeness here. We'll pour a couple of shots of the Macallan Lumina. This is much better than Costco. The Macallan Lumina, a fine single malt Scotch whiskey from the Macallan.
Self-defense.
But every case that you cite, Medina, Hickman, its progeny, all pertain to some act by the accused. And that battered spouse is an excuse, a justification, an explanation for those actions. How is your purported defense applicable legally?
That's the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that she did, what overt act or what omission. The overt act, was it zipping him into the suitcase? Was that the overt act that caused the death?
All of the battered spouse syndrome cases talk about a defensive issue. Not meaning defense, your side of the ledger issue. I mean an action in defense. Wagner fired the gun. It was accidental. Hickman fired a gun. There was an act that was done by the victim or by the defendant in those cases. And battered spouse was used as an explanation for why it is that they did. How is that applicable to the case at
I
bar?
assume they're going to say she overtly zipped him up in the suitcase. I assume they're going to say he was asking to be let out of the suitcase and she refused. She failed in a duty to act.
Well, don't make the prosecution's argument for them. All right.
Later on, she went upstairs and fell asleep. So it's either an act or an omission, but they're claiming an act or a series of acts led to the death of Mr. Torres, which they have alleged was directly caused by Sarah Boone's actions or non-actions.
And again, I think this is while he's fuddling around with his papers up there, this is a good point again to speak out in defense of Mr. Owens, the defense lawyer. He is the only lawyer in Florida that stepped forward and said he would represent Sarah Boone. Now he's doing it pro bono. He would represent her. He believes that she is entitled to representation and a fair trial with someone who is competent to preserve her rights and to protect her rights in trial. The only lawyer in Florida that stepped forward and said, as a matter of principle, parentheses, plus there is a little bit of self-promotion involved in this, but he's the only one that stepped forward and said, I will represent her. He's now managed to bring two other lawyers with him to the trial. No, he absolutely not, Sola Gracia. He is not. He is neither an idiot nor a snake, nor both. He is a true believer. He is a very, very successful and well-known defense lawyer in Florida. And as he said, she has this. He didn't jump on it immediately. He waited 2 weeks for someone else to step forward. Then they get a couple of weeks before trial, and he said nobody else has stepped forward. She is going to get massacred. Her rights are going to get trampled all over because there is no way she can defend herself. So he agreed to step forward and represent her. And initially, his representation was going to be limited to trying to get a good deal for her. He met with her in the jail and said, hey, look, I can meet with these. We can come up with a good plea deal for you. And he tried to sell her on the idea of a good plea deal. And they ended up in a shouting match and him going, all right, never mind. I'm not going to represent you. I just wanted to get you a good deal. You don't want it. So I'm out. I'm not going to represent you. And then a couple of days later, he came back and said, well, she came to him and said, I want to talk to you again. So she kind of had a little come to Jesus moment, and she's agreed to let him represent her. So he is doing the best he can. And he said, I just don't see it. His statements contradict themselves. How is he not dishonest? He is doing the best he can with what he has to deal with. He is essentially going into the World Series of Poker with half a deck. He has almost nothing to work with. And he is representing her in the best way he possibly can with what he's got to deal with. And you've got to give him credit for trial. He's got to know he's not going to win, but oftentimes being a defense lawyer is not about winning. It's about guaranteeing that due process is served. It's about guaranteeing that people's constitutional rights are protected. He's got to actively try to do what he can within the bounds of his ethical duties to protect his client. Now he's not talking out of both sides of his mouth. Sarah is the one that said it was an accident. He's the one that's saying it was battered spouse syndrome. So there is that distinction. There's that distinction that he's never said it was an accident. Sarah's statements to the police said it was an accident. Her statements to the law enforcement officer said it was an accident. He's saying it was a result of battered spouse. Now it's up to him to try to find a way to resolve what she has said with what he's trying to argue. And Porcelain Thunder says he's reaching a bit too much. He's got to. As you'll notice from this hearing and the next hearing, which is actually the hearing we watched last week or early this week, was he doesn't have case law to cite. He doesn't have any case law to back him up, and he knows that, which is why he's saying, I think, I feel, I believe the judge has discretion. I hope you use the discretion. He's doing the exact maximum he can possibly do. And I praise him for this. He's the one that got her to trial. He's the one that got her here. And as I said, he's got almost nothing to work with. And he knows that. And he's trying to do his best. So I would disagree that he's a liar or a snake or both, or an idiot or whatever it was. He's the guy that I would hope would be on my side if literally not a single lawyer in Florida wanted to touch my case. That's why it's stupid to try the battered spouse. Boone already ruined that route from the beginning. There's no other route to take that I can see. He's got to go with something. Insanity's ruled out. You got to go with something. He does have a history of abusive behavior. They got to run with that, I think. But as MG and I both have said from early on, she could have made this much easier if she just said, hey, we get into the freaky sex stuff. We got a suitcase kink. We got a bondage thing. We got the, a confinement fetish. We did that. And God, I was too freaking drunk. And, stupidly, I fell asleep. We didn't have a safe word set up. It was a kink thing gone wrong. Manslaughter out the door. But no, that's not how it went down. I absolutely completely agree with MG Law that if she would have just said it's a sex kink thing gone wrong, alcohol, unfortunate stuff, manslaughter, and she's out the door. But here's where we find ourselves. So let's get on with it. I appreciate your help. Wait a minute. Oh no. The unhung hero. Yes, that defense. Thanks. Thank you for participating on Unhung Hero. And by the way, no and stop are bad safe words. That's good. I still like that. That still makes me laugh.
Hickman, the defendant, stabbed the victim to death. And the justification was battered spouse. In Terry, which you provided to the court, Terry v. State, 467 Southern 2nd 761, it was firearm. What's the
Mechanism?
What is it?
They're the only ones that can answer that, Judge. That's why we asked for the statement
I don't
of particulars.
understand that circular logic. And the reason I don't is because it's your defense.
Okay. I'm assuming that they're claiming that she zipped him up in the suitcase against his will, would not let him out of the suitcase, and therefore he suffocated. So
What?
the act of zipping him up.
He's right. I wouldn't necessarily make this statement in court, but he's right.
And then the non-action of not letting him out when he asked to be let out constituted the offense of second-degree murder. That's the only explanation that we can come up with based on the report, based on the evidence we have. But Judge, you remember Marsha Thompson, the Palm Beach County case?
But there was a firearm.
There was a
She
firearm.
she discharged a firearm.
Remember Dr. Brannon said on the issue of imminent threat, it is in the mind of the battered spouse
But
woman.
right there's the words, imminent threat.
That's correct.
There was a threat. Now, I don't know all the cases. I don't know the facts and circumstances of that West Palm Beach case. I don't. I know snippets that you provided to me, but I haven't read any opinions on it. I don't know where it is on the DCA or appellate perspective, and trial court findings are not binding on another trial court. I mean, the case law is very, very clear on that.
Judge, the state doesn't know what happened the 2 minutes prior, or the minutes leading up to, the time leading up to the 2-minute video. The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that.
And she's going to have to testify. As he said, she's the only one that can make these statements. And that's a very dangerous situation to be in. So, yeah. Cheers. We're all caught up.
That's for her to
Appellant?
testify to.
Florida, the appellant has not cited, nor is our research located, any Florida case holding that evidence of battered spouse syndrome is admissible where the defendant claims accident rather than self-defense.
Who claims accident? Who claims?
Are you claiming self-defense?
Yes.
Well, that's the first time that I've heard that.
Judge, I just mentioned it a while ago.
The word self-defense never came out of your mouth.
Judge.
Words that you believe that the state's position is, what you believe that they're going to try to establish, that we don't know what happened before and after that video. The word self-defense have never been uttered this afternoon.
Judge, for the record.
For the record, this judge has had all the shit he can take. When your judge is looking at you like this and saying the things that this judge just said, spoiler alert, you're not going to win your argument. You're not going to win your argument. He's like, look, and he's pinning to what we just spent 5-10 minutes talking about. Are you arguing accident or are you arguing self-defense? And see, now what you have to understand, if you haven't already appreciated it, this judge has not seen the suitcase video. This judge has not seen the police station interrogation videos. This judge hasn't seen any of the evidence in this trial. So he, as he mentioned earlier in yesterday's stream, he's operating in a vacuum. So we know that she said all these contradictions. We know that she said it wasn't intentional. I didn't mean to. It wasn't intentional. But the judge doesn't know that. So we have to remember, he's like, I don't know what you're arguing. I don't know what's been said. I don't have access to any of this evidence. What are you arguing? Make your point. Is it accident or is it self-defense? And he very adamantly said, it's self-defense in almost a Muppet voice. So there you go. And he's saying, this is the first time X number of days before the hearing that you have uttered these self-defense magic words.
We're claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense.
Okay. All right.
Not accident, as they want to allege.
Okay. Does your compatriot want to provide response further? Okay. Mr. Henderson, good afternoon, sir. Can you hear us? If you can hear me, sir, you need to unmute yourself.
Oh,
I can, but I have some concerns because I'm getting reverb from you.
I am trying to talk you to now. Are you able to hear me better?
I am, but it's my
yeah, we can't hear you, bro.
that we're hearing back again through your microphone.
Turn that volume down.
All right, this may work.
Wait, I'm sorry. Bob with the Australian $5 Jeff의 안전한 문구는 콧 수염이 아닙니다입니다. Okay, that's not a great. What? All right, I got to try to figure out what the intention to type was here. We'll assume this went through Google Translate or Chat GPT, and we'll take this literal translation. Jeff's safe word is "it's not a mustache." Thanks, Bob. Thanks, Bob, for the super chat. For those of you that don't know, I have lived in Korea for 36 years and 3 weeks now. Tomorrow will be 36 years and 3 weeks. And this is Korean here you see on the screen. Bob has apparently put "it's not a mustache" is Jeff's safe word through a translator. Thank you very much. Jeff의 안전한 문구는 곧 수염이 아닙니다입니다. That's a terrible translation, but I get it. All right, thanks. And congratulations to myself and to all of you. We have 764 concurrent viewers, 509 likes. We hit the 500 like barrier. Thank you so much, everybody, for doing that. 600 would be super awesome. And then on to 7. And if you have not subscribed to the channel, I would please, we'll just treat this as our midstream grift here. I would be super, super thrilled. I would be super thrilled if you would do me the honor of reaching down there and smashing that subscribe button as well. We currently have 80,818 subscribers. That puts us 182 subscribers away from 81,000. Let's get us to 81,000 before the end of this trial. That would be super freaking awesome, and I would love each and every one of you for that. So thank you, everybody. Get down there and take our like and subscribe poll. After you have hit the like and subscribe, we have 717 votes on our like and subscribe poll, and it very clearly says like, subscribe, and then vote, but 200 of you have cheated. Repent. What do you think of the relationship between George and Sarah? This directly relates to this battered spouse syndrome that they're arguing. I'm sorry, he's not even calling it battered spouse syndrome. He's calling it battered woman syndrome, as if a man can't suffer from it. 4% of you said Sarah was the only battered party. 15% of you have said George was the only battered party. And a full 71% of you, more than 2/3, said they were both playing, giving and getting it. And 10% of you have chosen the empty category. So get down there and cast your vote, and we'll see how it works at the end. We'll see how it works out at the end. But I'm pretty sure that they were both giving and getting is going to win the day. All right, that's our midstream grift again. Just reminding you to do those YouTube-y things, like and subscribe, and thank you for getting us to 545 likes. You guys rock. All right, let's let them talk for a bit.
Mr. Henderson, we'll give this a shot, sir. You can go ahead.
Yes, sir. Can you hear me now?
I can, sir.
Is that better?
Yes, sir, it is.
Yes. Yes, Judge, I'd like to respond. But first, where I want to start is here. But just the self-defense, justifiable use of deadly force, justifiable use of non-deadly force. Those are defenses that do not require a notice at all. A defendant doesn't have to come in before trial and say that I am relying on self-defense. The standard is it's in the standard jury instructions, and before you can give that jury instruction, you have to have, and the cases are pretty clear, an indication or evidence. It's just a scintilla of evidence, is what the cases say, to get the instruction. There's no notice requirement in self-defense at all. Now, battered wife syndrome is not a defense in and of itself. There's no such thing as a defense there. It is a part of a jury instruction And the part of the jury instruction and what it explains is when you get to the point when you're starting to talk about imminent danger, and that because of this syndrome, they would perceive an imminent danger.
Okay, he's arguing that there has to be this imminent danger. Scarlett Sullivan says, yeah, Legal Vices, yes. Listen to Bob. Praise Bob. Just always praise Bob, the founder and leader of the Church of the Subgenius. Praise Bob. What Bob is saying is there has to be a perception of an imminent danger. But again, her interrogation at the police, at the sheriff's office contradicts that. She said, we had a wonderful night. We had a beautiful night. He's been doing so good since he's been going to his meetings and everything is great. We had a great night. We listened to music. We did puzzles. Then we decided to play hide and seek. And I accidentally fell asleep. There is no indication that she is making any statements that she was in imminent danger and reacted due to this battered woman syndrome. So yeah, this guy's what I think he's making a horrible argument. All right, let's go. Brandon says that's why you let your lawyer talk. For you, life's better that way. Yeah, if you got one of those, let them do the talking. Even if you think they suck less than you do. Trust me. Chloe Albert's revenge. Sarah, we're into rebirthing kink, and I fell asleep before he was born. Oh no. All right, Chloe Albert's that's 5 minutes in the penalty box for instigating. Oh no. Oh, thanks. Question mark. The extremely happy Simmer. Now tell us how to say that sentence in Korean properly. 저의 안전 단어가 코수염 아닙니다. There, that does it. It's much simpler than what was put out there. All right. Yeah, Scarlett Sullivan. Bob said mute and read the caption. I can't with this audio. It's brief, so just that's why I was pulling my earphone away from my ear because it was a little bit much. And we currently have 562 likes. Thank you so much for getting us over 500 likes.
Because what the self-defense instruction required is that the jury place themselves in the position of the defendant. In those circumstances, at that point, battered spouse goes to help explain those circumstances. So the first instruction that you have to get before you can even start talking about battered spouse is this. You have to get the self-defense instruction. So, and that would be decided based on the evidence at trial. The defendant doesn't have to come in and say, I am claiming self-defense. This is self-defense. There's no rule or circumstance to that extent. But there has to be testimony of self-defense. Now, once there's testimony of the self-defense part of it, then the court can give that instruction. If they find it sufficient, the testimony can give that instruction as to self-defense. Where the battered spouse comes in and it goes into a series, you have to have self-defense for some type of evidence of abuse before you can get into the battered spouse. And this is how it should work. There could be the testimony of Ms. Boone. There could be testimony that's actually in the notice from officers who responded to calls and actually observed physical injuries on Ms. Boone. There could be testimony from others, neighbors, or other people who observed injuries or certain things to Ms. Boone. But once you get to the point where you significantly or sufficiently apply that there is a battery or domestic violence situation that is ongoing, then, and not before that point, can the expert come in and testify?
All right. Not that I have anything to say. My ears just need a break from that audio. He's saying everybody can come in and testify. They have to testify. What I understand him saying is that, and weirdly, as horrible as this audio is, the closed captions are for once frighteningly accurate. So good job to the auto closed captioning system for figuring this out. I believe what he's saying is everybody can come in and testify as to what happened, and they have to lay this foundation, and then the expert can come in and testify that all of these things make up the diagnosis, if you will, of battered woman syndrome. But how do they get around this whole deal? Where, because he's saying there has to be this imminent threat, and she, in her statement to the law enforcement officers, specifically said there was no imminent threat. It was a beautiful night, listening to music, playing games, doing puzzles, playing hide and seek, having a great time, laughing. All right. Well, oof. All right, people, gear up for your ears. Let's see how much longer this dude is going to be talking. Okay. It looks like he's going to be talking for about 4 more minutes. Let's go. 4 more. We can suffer through 4 more minutes of this, but if you have to, mute and just read the captions, because the captions are actually very, very accurate.
So the stopgaps on this that are built into our system. First, there has to be some accountability or some evidence of self-defense. Secondly, there has to be some evidence that will support the expert's testimony to become relevant at that time. Once the expert's testimony becomes relevant, then the expert can testify about these are the symptoms that I observed, this is what I watched, this is where it came from, this was interviews, this was reviewing other type of data and other types of things that preparing their expert opinion. So after that point, Jeff, when you get to that point, then it doesn't become a judicial act at that point in time. What it becomes a jury question. And it is up to the jury to decide. And what it does, and it doesn't say that battered spouse is a defense. What it will talk about in the jury instruction is this is something that a battered woman would do. Under these circumstances, if you find it credible, that you can consider. And that's what it does. So we at the beginning here, when we start talking about motions to strike, because if I think the case was Wagner, there wasn't any testimony there. Wagner's testimony was accident and that head. And I really put no one would even the ruling of that.
Okay, I can't last 4 minutes. He's making some good points, but he's got 2 more minutes of this nonsense. Oof. I may be going deaf. All right, and again, I have nothing to say here. I'm just giving our ears just a slight little break, so that we can deal with this. Right, Buddha says, "Dude, I'm about to plead guilty if this keeps going. I can't last 4 minutes." And clipped. Oh yeah, right. Thanks, Bob. Stop, people. Jeebus. This audio is how you get a grown man to climb into a Samsonite. Yerp. Well, that's something we've continuously mentioned, Philip Kraft. I never heard of hide and seek where the seeker is hiding the person. And that's what she said. She's like, "Oh yeah, we were playing hide and seek. And we brought the suitcase out, and we thought it would be funny for him to get in, and we zipped him up, and I thought he would squirm around for a little bit, but then I fell asleep." So literally she's saying we were playing hide and seek. We put the suitcase in the middle of the floor, in the middle of the living room, and he got in it, and I zipped him up. That is literally the worst way to play hide and seek, both from the perspective of the hider and the seeker. The the hider knows that the seeker knows where they are because the seeker put them there, and the seeker doesn't have to look very hard because they put the hider there. It literally makes no sense. Well, he told him to sort his audio out, but it never did. So I think the judge is just powering through. At least they have the benefit of having open speakers, where I guess a lot of us have earphones and earbuds in, and he's doing this directly in our ear. 2 more minutes. Let's power through, people. Let's power through.
What's the testimony?
Okay.
In this case, we do not have testimony. What we have is to say, in this case, saying the discovery in this case showed it. But that's not solved. These women have to know better on the testimony of the report, either testimony itself, physical evidence.
Mr. Henderson, we're having a difficult time understanding you, sir.
I'm sorry, Judge. Is that better?
Maybe. Madam Court Reporter and I were having a little bit of difficulty hearing you at the end. You seem to be projecting away from where your microphone is.
Thank you, Judge.
Okay.
My bad. No, your shitty audio is what. Just stop talking, bruh.
Madam Court Reporter. We will do our best, sir. Keep going.
Oh no! Don't keep.
Yeah. So
Don't keep going. He's got 1 minute.
It's simply this. And to the court, here's the evidence that permitted at trial. The court cannot make certain decisions. The court can't make a decision if justify the use of non-deadly or justify the use of deadly force is appropriate to give and to the evidence at trial. At that point in time, the court has to make a decision if, after evidence, if the expert's testimony is even relevant. So if there is a testimony to prove the relevancy or to show the relevancy of the expert's testimony, then that expert can't come up and talk about that as fast. Now, if you don't get the expert to talk about that as spouse and render an expert opinion, battered spouse is out the window. So then you're just on self-defense at that time. But that argument and that decision can only be made after the evidence is put in that trial. And that's all I have, Judge. Thanks.
Oh, thank Christ, he's done. Whew, I apologize for that, people. That was some of the most painful audio I've ever had to deal with in my entire streaming life. And I agree with the battered ear syndrome. Bob says, never use a built-in microphone. And David Nelson says, does this court reporter get hazard pay for this? What I think happened, clearly someone is holding a phone. So they're on an iPhone or an Android or something. They're holding the phone. They're on Zoom. They're in an echoey room. The volume on Zoom is pumped all the way up so he can hear through the audio. And so that he's going through the built-in mic on the phone. Meanwhile, the audio is projecting in this echoey room. So he's getting this big feedback loop. That's the best I can figure out. Oh, Lord. Duncan Ido says, am I having deja vu again, or have we watched this hearing like twice already? I have never watched this hearing. You've watched it elsewhere. That's why we're watching it. I have never seen this hearing. Let's go. Brandon says, if the truth don't find you, Zelle and absinthe will. Yeah. We do have an additional $300 donation from Let's Go Brandon. Whoo, boy. All right. Thank you very, 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 very much. We'll work our way through I'll do at least one absinthe, but probably have to do 2 whiskeys or I'll die. It's been a minute, brother. Thank you very much for the whatever it is that I'm going through right now. Thank you very much for that. Duncan Idaho. It's a 2005 headset microphone sitting on the end of a PVC pipe. or just the built-in audio and speakers of a phone. One of the two. Hide and seek. I don't know about that one, says Duncan Idaho. Also, yeah. Bob says, Bob with the $5 Australian says, 아니 그녀는 이 밥의 말을 들으려는 것이 있습니다. 비디오를 음소거하고 타이 캡션을 읽어주세요. Wow, that's a really awful translation. What could that be? Ani's no. 그녀의 밥 or food? Eh? Oh, Bob. 그녀의 밥의 말. Bob is also food, is like rice. 그녀의 밥의 말을 들으려는 것입니다. No, she was trying to listen to Bob's words. She was trying to listen to Bob's words. 비디오를 음소하고, so mute the audio and read the Thai caption. Read the Thailand captions. I don't know what that part means, but wow. Thanks, Bob, for the very confusing internet translation of English to Korean. 아니, 그녀는 이 밥의 말을 들으려는 것입니다. 비디오를 음소하고 Thai caption 읽어주세요. I don't know what the read the Thailand captions is all about, but anyway, thanks. We don't have to hear from this guy anymore, but I've got to work my way through a few beverages right now.
Mr. J, any response?
It sounds like we're largely on the same page. The one point that I would strongly disagree with is that this evidence of battered spouse syndrome is relevant to the subjective belief of the victim or the defendant. That is not what evidence is used for. It's used to help a jury understand what an objectively reasonable person would do in those circumstances. And there's more cases that I have not cited because I know that would be raised today, but they kicked out PTSD testimony just last year, I believe it's an Okendo, because it was going to the subjective beliefs of the defendant rather than helping the jury understand why an objectively reasonable person in a battered spouse syndrome would stay. With that notwithstanding, it appears we're on the same page that the jury should not be hearing anything about battered spouse until the predicates are laid. And from the state's position, to help us prepare for trial, pleading should be sufficient. And it's still our position that the pleading was insufficient. The state is well aware of the past violence between the two of them, with her being the aggressor and the decedent being the aggressor. There's evidence of that all throughout the discovery. But what isn't present anywhere in the discovery and what left the state at a lapse in understanding this defense in particular was, did this violence cause her to suffer from battered spouse syndrome? And what is this evidence going to be? Was he isolating her? Was he keeping her away from family and friends? Was he psychologically breaking her down? Was he doing any of these things that are a component of the battered spouse syndrome? Because all we have is her statements, which are almost 100 pages long, to the sheriff's office, where she repeatedly says that night that nobody laid hands on one another. It was a great night. We were hanging out, drinking wine, doing puzzles, painting, dancing with the dog. And then, like everybody else, we were playing hide and seek. And he got into the suitcase and I accidentally went to sleep. And then she's shown her video. But her statements are all that it's an accident and that there was never any claim of violence that day between the two of them. So that's wherein the state's confusion lies. And I don't know how we're going to go about this at trial, if the defendant's going to have to testify in a narrative form, if she's going to come in and testify 100% differently than how she gave statements to law enforcement. But that's where we're at, is we don't want this in front of the jury until all of the requirements are met. And as far as I know, the only person that can say that it was a justifiable use of force that night is her, because it was only her and the decedent in the home that night. And thus far, she has not made any statements about a justifiable use of force. And then our second complaint.
Absolutely correct. Nothing, not a single statement she has really made to date says that she was acting in some sort of self-defense or justifiable reason for zipping him up in a suitcase and leaving him there. To the contrary, everything she said thus far is it was an accident. I didn't mean to do it. It wasn't intentional. And they were having a great time. And this was just part of their games for the night. So got to side with the prosecutor. And again, as he pointed out, she's the only one that can testify to this. So she has little to no chance at all as it is. But to have even a microscopic chance, she must take the stand in her defense. If she doesn't, it's 100% she's gone. Probably for life. I would guess that it would be like 40 years, before she's eligible for parole. 40 years to life. But yeah, she has to take the stand. She's got to.
About the intent to rely on the syndrome, again, without repeating myself, is it just sets forth that there was past violence between the two of them, but no particulars about what actually makes up the rest of the syndrome. Thank you.
Right.
Any other final positions offered in rebuttal to the state's argument, either Mr. Owens or Mr. Henderson?
Well, I'll let Mr. Henderson go, but just as it relates to Ms. Boone's testimony, that's what jury trials are for.
Mr. Henderson, any further arguments, sir?
Okay.
You're muted. You will have to unmute yourself. Mr. Henderson, you're still muted, sir.
Please stay muted. Please stay muted.
I'm sorry. Can you hear me now?
Loud and clear, sir. Any other additional argument in rebuttal?
Yes, Judge. The state is going to have the opportunity to depose the expert, Ms. Harper, who can tie those things together. That's why we have experts who know about these things and who have the knowledge, who can tie these things together and tell why she's of the opinion that she was suffering from battered spouse at that time. The notice is simply to require to let them know that we're seeking this avenue, and here are the witnesses that we're using to seek the avenue. We don't have to list a specific number of witnesses. It's just the ones that we intend to use. And as Mr. Owens has told you, this is an ongoing process, and we'll probably be adding more. But that's all I have. Thank you.
All right. Thank you
You're
very
welcome,
much.
whatever you said.
The court is going to take the issue under advisement and provide a written order. I'll endeavor to do that by the end of the week. Last is the defendant's motion for enlargement of time filed September 17th.
They want more time.
Mr. J, have you had the opportunity to review that?
Yes, Your Honor.
Okay, all right. Any problems with proceeding with that this afternoon?
No, Your Honor.
Okay, very good. All right, I have reviewed that motion. Mr. Owens, you may proceed, sir.
Jen, I do have about 2 or 3 other issues that we need to address, but I've asked for some time. I think there was an order. I know there was an order that you had submitted to writing and that was filed with the clerk's file that indicated that you wanted some things from the defense and from the state by certain dates. And I think that's a typo on paragraph 3. I said August 17. That should be September 17 on paragraph 3, Judge, of my defendant's motion for enlargement of time.
It says September 5 on paragraph 3.
Are you looking at my defendant's motion for enlargement of time?
Yes, sir.
Yes, Sarah
Defendant
now
versus
has
Dr.
3
Julie
lawyers.
Harper met with
Him and
defendant
the
Sarah
2
Boone on
ladies
Thursday,
sitting at
September
the
5,
table with.
2024? Am I looking at the wrong
Okay.
thing?
I'm sorry. I was looking at the wrong one. If you look at the second page,
Yes, sir.
paragraph 7,
Yes.
that should be September 17.
Yeah, got it.
Okay.
I mean, obviously, the court's order, the August 5 order speaks for itself.
Judge, and as you know, we came in late.
And the August 5 order he's referring to is the order that said the timeline is the timeline. We ain't adjusting it. So he sits there with his Florida State University mug, smiles smugly at the defense lawyer and says, "You ain't getting no more time. Sorry."
Dr. Harper formed an opinion that week. We filed a notice of intent rely on battered spouse. It's ongoing. That's all I can say. We're working, we're doing everything we can to uncover evidence consistent with our defense. The problem is it's 4.5 years ago, and the apartment complex in Winter Park has changed hands. So we're trying to run down the employees. We're trying to run down the other tenants of the place. We're trying to run down medical records. That office manager is critical. We've taken her deposition, but we can't find her. Brandon, I think it's Moats, the neighbor that lived right next door to Miss Boone and Mr. Torres, and they shared a wall, is a critical witness in the case. We're trying to locate him.
I'm not sure you want the guy that shares the wall with Sarah as a witness. I can't remember which of the two guys in the house said to the police that it sounded like something heavy fell down the stairs, which supports the allegation or the rumor, I guess it is at this point, because it hasn't been made in court, that he was put in the suitcase upstairs and pushed down the stairs in the suitcase. The next door neighbor, it was one of them. There was like was it Brandon or was it Brute? It was a B word. We'll call it Brandon and Vincent. There was okay. So people Northwest was saying it's Vincent. Yeah, they're roommates. The Brandon and Vinny. It was Vinny that said it sounded like somebody was being, something heavy was being pushed down the stairs at night. So, not sure we want these guys as witnesses for the defense.
As you know, 4.5 years, people move. So we need more time, is my point. We're doing everything we can. We're working diligently. Billy Lane, the investigator, is working diligently to try to gather the information I'm asking him to gather. Coupled with the fact that we've got this phone that we're going to be extracting, I'm in hopes of in a few days. And I know that the state had extracted the phone and given us a lot of the data from the phone, but Ms. Boone says it's incomplete. That's the reason we want our own expert to extract it, that will be able to assist us in establishing evidence and testimony that she is a battered spouse and was a battered spouse prior to this event. But because of that, Judge, we haven't had time to complete that. And as I said in my motion for enlargement of time, we're asking to be flexible on some time limits up to and during the week of the trial, because we're going to be working that entire trial. Like I said, there's 18 days until trial starts. It's going to be a 2-week trial.
There's less than that now, buddy.
I don't know when some of this information is going to come, but I assume every other day we'll probably be amending the discovery, the reciprocal discovery, and amending the notice of intent to rely on insanity or rely on battered spouse if we find other evidence that corroborates that. So we're just asking the court, and I know there's a rule that specifically this rule 3.050 that allows for this request. Thank you.
Thank you very much. State, any response?
Certainly the state is not going to be okay with them conducting their investigation once jeopardy has been attached. That is completely unfair to the state. This is the defendant's trial, not Mr. Owen's trial. She has been on notice of these charges since February 25th of 2020. She has gone through countless attorneys here who did not pursue this battered spouse syndrome defense, even though they had consulted with Dr. Harper back in 2020. And I also find that a very interesting statement, that this is not Mr. Owen's trial. This is her trial. We're running on her timeline, not Mr. Owens's timeline. Mr. Owens has been around 2 weeks. Sarah has known of these charges and what she needs to prove and do this, along with 8 other lawyers, some of which had to conflict out, but she's known about this since 2020. Her timeline for this trial runs 4.5 years. I like this. It's a brutal statement, but it's a brutal truth. This is her trial, not his. We go off her timeline, not the timeline of his involvement in it.
This guy's sharp. Everybody here is sharp. The judge is amazingly sharp. The prosecution is a great guy. I haven't seen any fouls he's committed yet. He's been above board, doing everything the way it needs to get done. And even the defense lawyer is clearly sharp. He's making these arguments that are very, very difficult to make, but he knows he has to make them. So this is actually a very, very good trial, and it's shaping up to be much better than I thought it would be. I thought it would be an absolute shit show, but it's shaping up to be a good trial.
Crux of that issue is going to revolve around her having to testify in the form of a narrative given her prior statements. So the state opposes any enlargement in time. The defendant has been on notice and has had centuries probably of legal expertise at her disposal for the last 4 years. And there may come a point in time where the state has to request a continuance prior to trial. But if this enlargement is granted, but certainly once jeopardy is attached, that's not the time to be doing discovery. She's had 4 years to do this.
And jeopardy normally attaches when the jury
Any other final
election
arguments, Mr. Owens?
commences.
No, sir.
Okay. I'm just rereading the rule. Give me a moment.
Or at latest when a jury is impaneled. Yes.
Mr. Owens, as I stated when we had our hearing on September 3rd, at that point in time, the court had outlined the history of the case, the court's prior findings, the numerous experts that had been retained throughout this case. And I understand the position that you find yourselves in. But at the same token, based on the same analysis that the court had relied upon in its oral pronouncement in denying your continuance on September the 3rd, I'm going to grant your motion and deny your motion in part. With regard to the filing of objections to the state's exhibits, by your own statement, you're still in the process of going through those. The deadline expired on September 17th. So I believe that we're using the second portion of the rule with regard to that issue because there was a requirement to provide those names, and this motion was filed on the 17th. So I'm going to grant your motion in part with regard to filing objections for the state's exhibits. I will give you up until the time that we're having our trial case management on September 26th to file any additional objections to any of the state's exhibits. With regard, however, to the filing of a witness and exhibit list, I agree with the state. We can't be amending once jeopardy attaches to provide additional experts or any witnesses at that point in time.
You're talking about jeopardy when the jury is sworn
Correct.
on that
Okay.
Monday, October 7th?
If we're lucky enough to get one on Monday.
All right. So in Florida, jeopardy attaches,
So,
meaning they
just so
can't
that
be
you
retried
understand.
and whatnot. Once the jury is sworn in, the final jury, there's two swearing ins of juries. The large jury pool is sworn in at the beginning of voir dire, as we say in Utah, voir dire, as you uneducated masses call it. At the beginning of voir dire, the jury is the pool is sworn in, and then once the final jurors that are going to be sitting in trial, which includes the 12 main jurors and the however many alternates, when they are sworn in, then jeopardy attaches. And he's saying that once the jury has been sworn in, you can't continue to look for evidence. You can't continue to do this stuff.
I've ordered a couple hundred people for that week because I don't know how long jury selection is going to take. I don't know what people know about this case.
Judge,
So my intention is to run 50 people in the morning. So I'm just letting y'all full disclosure here, what my thoughts are. 50 people in the morning, get rid of language, get rid of cause. And if those persons who don't know anything about this case, I'm going to ask them to come back either Tuesday or Wednesday. And then we're going to run another 50 at 1:30. Get rid of our cause challenges, those who can't be here for 2 weeks, those who've just recently given birth, all the statutory cause reasons that they can't be here. I'm going to ask them to come back. And if we've got 40 people, 50 people at the end of Monday, we'll start Tuesday and we'll start whittling it down. and I can turn over when I'm done with my colloquy. My voir dire is about an hour and a half, 2 hours. And then I'll turn it over to the state and I'll turn it over to you and we can whittle it down from there. But if it takes us more time to get a sufficient panel because of the amount of time and other causes or preconceived notions about this case that can't be set aside, we may not be picking a final jury until Wednesday in this case.
Is this set for 2 or 3 weeks?
2 weeks. 2 weeks. Now, it was
I thought it
originally
was
set
3.
for 3 weeks.
Okay.
And then when we talked about it, when you came on board, we had shrunk that to 2. Now, if we think that that may change, I'd rather discuss that now than a week from now. If you think we need 3 weeks, I can try my best to make that happen. But I respectfully need to know that sooner rather than later.
Go
Because in all
3
candor,
weeks.
I don't know how long it's going to take us to get a jury.
I did not anticipate, I anticipated we were going to be able to pick a jury in one day.
I would love to be that bullish. I hope we can. I'd love to be able to.
Now,
I'm
we've
just
had
telling
2
you what
hurricanes
I've been working
intervening,
with jury
so-
services, that I've got 50 people teed up for 9 a.m. I got 50 people teed up for 1:30. And that will continue throughout the day, the week. It's easier for me to say, we don't need you, go home. You don't need to show up for jury service, than it is, I need bodies and we don't have them. Now, if we're able to get a jury in one day, fabulous. But if we can't, I have that backup.
I believe if we pick the jury in one day, we could try the case in 2 weeks. But if it's going to take a little bit longer, and again, we don't know from now until October 7th, what other evidence or what other witnesses.
We need
we're
3
gonna
weeks.
uncover.
We've
So
had
I
2
think
hurricanes.
in the abundance of caution, I'm going to ask the court, if possible, to set 3 weeks. I don't think it's going to take 3 weeks, but I don't know how long jury selection is going to be. I don't know what additional evidence we're going to uncover, additional witnesses from now until October 7th. So to be on the safe side, I would ask for 3.
Okay, all right. I'll see what I can do there, and I'll have Anita report back to both of you.
And Northwest says in 2022, the trial was scheduled for 3.5 days. Yeah, and I assume that would be opening arguments, opening statements by both sides, and the prosecution going, the video, just watch it. The prosecution rests. And then the defense going, just please keep an open mind. And so, yeah, back in 2022, things were much simpler.
Judge, and the main reason, I think all these other lawyers, they didn't have an expert that had tendered that opinion about her spouse. So we started on this path on that Friday when Dr. Harper called me and I filed the notice of intent to seek corroborative evidence, corroborative witnesses that she was battered. So that didn't really start until that day, which was September 6th. And that's why, and again, this was an event that occurred 4.5 years ago, trying to locate witnesses. It's just taking time. I understand about the jury being sworn and we shouldn't be allowed to ask additional witnesses to come in. So I agree with the state on that. I agree with the court. But I would ask up until the time we pick the jury that we be allowed to amend reciprocal discovery and amend our notice of intent to add additional witnesses and additional evidence.
Mr. J, any other further positions, sir?
There just may come a point in time, Judge, if you don't set a deadline, that the state has to ask for continuance.
The deadline is going to be for exceptions to the state's evidence, providing of a witness and exhibit list for the defense at trial case management next week, September 26th at 9 a.m., in addition to all the reasons that the court placed on the record on September 3rd during the motion to continue. My JA has advised that Mr. Lake has appeared virtually with regard to the motion to appoint clinical psychologist. Mr. Lake, can you hear me?
Yes, I can, Your Honor.
Can I get your appearance for the record, please?
Yes, Christian Lake on behalf of the Justice Administrative Commission.
All right, thank you, sir. Earlier today, before your participation, I know that Mr. Owens had provided you certain cost motions regarding the forensic psychologist.
This guy, he is from the JAC. They're the people that make all the decisions regarding costs for indigent defendants. So he's the one that authorizes how much, whether she can have money for a certain expert and how much they can bill and what the cap of their billable amount is. So this is just financial stuff here.
Dr. Harper and the crime scene investigator, Dr. Birkeland. You had advised as the JACS's positions on those motions. Your email has been filed in the court file. Subsequent to that, a motion to appoint clinical psychologist regarding Dr. Michael Brannon was filed. That was just filed yesterday. I know my judicial assistant sent you a copy of it. Have you had the opportunity to review that motion? And if so, what is JACS's position?
Your Honor, just briefly, we did review the motion. Although we're not contesting it beyond objecting, we do object to any rate in excess of the rates established by law, or we acknowledge for this type of expert that it would not be uncommon to approve a rate of $200 an hour. It's if that does exceed the rates established for this circuit.
Mr. Lake, I hate to interrupt you, sir. Madam Court Reporter's having a difficult time hearing you. If you could start over.
Okay, one guy having an audio problem is that guy's problem. Everybody having an audio problem, that's a court problem. Sorry, Judge. This is on whoever your audio people are.
And slow down just a smidge for us, we would greatly appreciate it.
Not a problem, Your Honor. We did review the motion to appoint the expert. Just to give the court some background, because I went back and looked through our files. So far, the defense has incurred, this is prior to Mr. Owen's involvement, but so far the defense had previously incurred $7,500 for one mental health expert, and that's the same mental health expert as being, not this expert, but was the other expert being requested, was requested by the defense in the other two motions. The defense also incurred $1,800 for a mental health expert that was hired by Ms. Cashman. That was, let me just get the right name, I don't want to say the wrong name, but she was paid $1,800. She was retained in relation to the issue that was before the court today, the battered spouse syndrome. And now the defense is requesting a third mental health, but also at the rate of $200 an hour. Based on the nature of the case, Your Honor, we have no real, other than objecting to the rate because it does exceed for the circuit, we don't have any other concerns about the appointment of the expert. It would be the third mental health expert appointed to assist the defense. But that really, I mean, ultimately that's your call whether to allow the defense to incur costs for a third mental health expert.
The motion reflects the rate is $200 per hour. Is that in excess of the JACS rate?
Your Honor, it's in excess of the rates for the circuit. Those were the rates that were adopted back in by the old Immigrant Services Committee back in 2007. We essentially generally don't ask for a hearing unless the rate is over $200 an hour. So we generally, again, we acknowledge that is, the rates generally range for mental health experts range between $150 to $200 an hour. So we don't particularly object to them. As far as what the rates were at that time, they are posted on our website, and I'm pulling them up right now because for the Ninth Circuit, the rates for medical doctors and psychologists are $160 an hour for out-of-court services and $178 an hour for in-court services.
State anything further?
Nothing on this.
Okay, all right. The court is going to grant the motion to appoint Dr. Brannon. I know that the state advised that this is not going to be nunc-pro-tunc because I've received nothing from you,
Not
Mr.
the nunc-pro-tunc again. We went through nunc-pro-tunc yesterday, and I promise you would never, ever, for the remainder of your life, hear that term nunc-pro-tunc again. It just means it means then for now, or like now for then. Okay, so you're basically revising or correcting something that was done before. So they did something that needs to be revised, changed, renewed, altered in some way. And instead of just saying, okay, we're going to change this out, they use the Latin phrase nunc-pro-tunc, which I swore to God you would never hear again for the rest of your life. And he just dropped another nunc.
Owen said he's done any work yet.
That's correct.
Okay, so this will be effective as of today, the 17th of February.
September.
Yeah, is that not what I just said? I'm sorry if I said a different date. I will take it under advisement, the issues pertaining to the battered spouse syndrome, and provide a written order. You had advised there were some other issues that you wanted to bring up, sir.
This relates to the investigator, Billy Lane, who's working with the defense.
So Billy Lane is the court-appointed defense investigator. He works for a great company called Prison Break, which I think is pretty cool. So he's the one that's doing all of the investigation work for Sarah Boone.
And his potential costs up to the trial.
He wants to get paid.
Are these being hand filed now?
Mr. Lane handed them to me right before we came in, so I'm going to have to scan these in and file them.
Okay.
I wanted the court to be aware. If you want to address it at the September 26th case management conference, we can do it then.
Let's do that. Just do me a favor if you could, sir. Once they're filed, just forward them to Ms. Barrios.
Okay.
So that I've got hard copies of them.
All right, I'll do
I'll
that.
give these back to you, sir.
Judge, the other thing was, of course, we've got trial coming up quickly, and generally, when in a courtroom, I do opening statement, I maybe have some demonstrative aids, but I walk around, and I understand here that we've got to be in front of a microphone. Is there any way we can set up, maybe the defense can set up a system where we can wear a mic so that we can walk to some degree?
I will have to check with.
Oh, please, for the love of God, let him do that. What he's asking for is like a strap-on FM mic so that they don't have to be stuck in front of the microphone and not talking into the microphone all the time. He wants a wireless mic strapped to them. Please, Judge, for the love of God, give them what they want. I think the last time we actually had lawyers wearing wireless FM mics was during the O.J. Simpson trial. I honest to God think that's the last time we ever had FM mics strapped to lawyers. Please let them do it. Please. For the love of all that's holy and audio and all of us YouTube streamers out there, let them wear wireless mics, please.
Court admin.
All right. And then the other thing is we would like Sarah to wear street clothes. So do I need to file something?
I have, get in touch with the public defender's office. When Miss Boone was representing herself, I had coordinated and communicated with the public defender's office multiple times in an attempt to obtain clothing. Before you came on board, Mr. Owens, Barry Click, BARRIECLICK, had provided the total amount of clothing that they had that would fit Miss Boone, including shirts, pants, slacks, skirts. And that was the time where she would be allowed free reign and was going to have the shock device on her lower leg. I would ask that you can email Miss Click. You can find her information on the Florida Bar webpage and ask her if the public defender would assist you in provided clothing. They were going to, while Ms. Boone was representing herself, and I imagine that offer would still be extended.
Judge, and I anticipate 2 more pretrial hearings. 1 is the case management conference, and 2, if I file the motion to suppress the statement made during the interrogation, we would probably have to set a separate date. Can she wear street clothes at those 2 hearings?
If you could get it to her.
Okay.
So that's something you have to work with corrections. I don't know that they're going to let you do that.
Now, when it comes time to trial, she would like for us to have some makeup for her and somebody to.
And they've already, in the next hearing after this one, they denied her any makeup, basically, on the grounds that the prison security people are concerned because they don't know what's in the makeup. I guess they're concerned that there might be some, contact-based drugs, and I don't know what they're concerned about, but the prison security people said, no, we can't let her have makeup. And I believe the judge said something like, she's coming, the jury's coming in at 9 a.m. If you can do something between now and then, whatever. So makeup is likely off the table for her. It didn't make a lot of sense, but the court gives a lot of deference to the jail folks in that regard.
Fix her hair in a way that's presentable to the jury that she would like to be presented. Do I need to file a motion on that, or?
I think you're going to have to.
Okay. I believe that's all I have, Judge.
Okay, all right. Anything else, State, we need to address? All right, anything else, Mr. Owens, or from your co-counsel?
No, Judge.
Okay, I will see you all on September 26th at 9:00 in the morning, and I will endeavor to
why
get
is
you a
there-
ruling on
why
the
is there
battered
still
spouse
15
issue as soon
minutes
as
left of
practical,
hearing?
hopefully by tomorrow.
Thank you.
Oh.
All right, thank you all very much.
All right,
We're off
it's
the
all
record.
just dead air. Cool. Great. I thought we still had 20 more minutes, but we've just basically got dead air, them leaving the courtroom and dead air for 20 minutes. Oh, thank God. All right, that was the end of the final hearing that we haven't covered. We covered the hearing following this, which was the last hearing we did. The judge ruled in favor of the defense for some things that didn't matter. Like, okay, she doesn't have to be shackled in court. But as far as all of the substantive legal arguments, he sided with the prosecution. There was no violation of Miranda warnings. There's no problem moving forward. You're not getting an extension of time. So we're still on. And the question was asked a little while ago it was Crystal Pooh. Any idea if the jury selection on Monday is still on? Yes, it is. Oh, is that a Pond Scum Posse avatar you have there? Oh, that's cute. Christy Pooh says, any idea if jury selection is on for Monday? Yes, it's still on for Monday. They're going to reconvene. And what he just said was probably the most informative statement he said thus far about how they're going to handle it. They're going to try to narrow it down to 40 or so people on the first day. And I believe at the next hearing, he said, we'll do the arguments on the outstanding motions after we've done that, and then we'll bring in the final 40 and we'll impanel the jury, swear them in, and take off. So I would expect, let's say, Monday to narrow it down to 40. Monday, probably no stream. Tuesday, possibly into Wednesday, maybe some motions, but I think we can get all the motions done on a Tuesday. Then bring the jurors back on a Wednesday to narrow it down to the final 12 plus however many alternates they have in Florida. And then I would expect, it could be earlier, could be later, but I would expect the opening statements to begin in the Sarah Boone trial on Thursday. Could be Wednesday, could be Friday, but we'll have to play it by ear and see what happens. In the meantime, what are we going to do? What's our plan here on Legal Vices, the greatest lawfluencer on the entire interwebs? What are we going to do? Well, tomorrow we're going to look at the motions. All the motions that we haven't covered yet. It'll likely be a slightly shorter stream because there's not a lot of motions we haven't covered. And also because I normally stream, I live in Korea, for those of you who don't know. I normally stream from 10 p.m. to midnight my time. Tomorrow will be Friday, so it would be Friday 10 p.m. to midnight normally, but I have to be across town to do my lawyerly duties and sit in on a board meeting at 8 a.m. on Saturday morning. That's cruel and unusual as far as I'm concerned, but hey, it's part of the job. So likely we will finish a little bit early so I can get some sleep to wake up super, super early, drive across town and sit in a board meeting from about 8 a.m. Saturday morning until roughly around 2 p.m. Then I have two Russian friends with birthdays. They're having a joint birthday party, which is going to mean I'm probably going to be incoherent by about 4 p.m. on Saturday afternoon. So tomorrow we'll cover the motions we haven't covered yet. Which let me see. That includes such things as the autopsy report. We're going to look at the autopsy report. We're going to read through that. A motion in limine, a response to a motion in limine to eliminate certain parts of the interrogation video by the police. So we're going to review some hearing notes from last time. It has some important information. And a motion to exclude evidence regarding battered spouse. We're going to be looking at that. And then a letter that was filed in August, on August 26th, a letter that was filed on August 30th, and a letter written by Sarah Boone. So we'll be looking at at a bunch of stuff tomorrow, but they're not lengthy documents. So we'll probably go about an hour and a half tomorrow. Then we'll have the weekend. Monday, we're just going to have to see what the court does. If it goes according to plan and there's jury selection, I'm going to try to go back to the beginning and read the complaint, read the information, and talk about some of those things. Go back to the very beginning of the prosecution's case to refresh our memory for when the hearings start. That's what we're looking. That's what we're looking at. And right now I'm looking to see where we can send us right now when I shut this thing down. Normally I would send us to Nick Starro, but he's in chat here, or Kat Not Williams, who is not in chat right now. They're covering the YSL, the Young Thug trial, but they're taking a day off for that. So I need to look where we can send us. Where can we redirect you to? Who is streaming now about something? We're gonna send you to Meme Copium. Meme Copium, who is covering the sunrise damage report regarding Hurricane Milton and the Lieutenant Dan saga. Lieutenant Dan is the guy who said, "I'm not leaving, I'm not evacuating, I'm going to stay here in my little houseboat," and his little houseboat got beat to shit. So we'll send you on over to Meme Copium real quick. He's probably going to end real quick soon. But anyway, what I have to do before we close, I owe Let's Go Brandon a shot of absinthe. So we'll close it out as I pay off my final bit of debt. And then I've had beverages tonight. So I'm going to go crawl into a suitcase and go to sleep, I think. Cheers. Yum. All right. We're going to send you on over to Meme Copium. I will see you tomorrow at 9 a.m. Eastern time, 2 p.m. UK time, 10 p.m. Korea, Japan time, and midnight Australia Eastern Daylight Time. Mods, thank you for being here. Thank you so much. Chat, thank you for being here. Thank you. Let's Go Brandon. Goes without saying. Thank you for it's been a minute. Thank you for everything. Chat, thank you for all of your super chats, your gifted memberships, your purchase memberships. I couldn't do this without you. I wouldn't want to do this without you. How many people do we have still watching here? 672 of you have just dropped to 502 because we're ending. All 502 of you that are still here, thank you so much. I couldn't do it without you. The Vice Squad chat is the greatest chat on the entire internet. Seriously, respect, love to all of you. We'll see you tomorrow. Thank you. And our like and subscribe poll. This is your last chance to get down there and hit that like button. We currently have 648 likes, just 52 more to get us to 700 likes. We can do that. Boom, that fast. And hit the subscribe button because let's see what happened with the subscriptions. We are at 80,827 subscribers. We picked up about 27 subscribers today. Cool. So that means we are 133 subscribers away from 81,000, and it's all due to you. We'll see you tomorrow, people. Take care. And we have, I guess they're over here on this camera, day 31 of the Emotional Support Potato Pig Dog Cam. Let's see if we can make it 32 days tomorrow. All right, with that, I'm out. Go tell Meme Copium Legal Vices sent you, and let's find out about the latest on Hurricane Milton that devastated the Florida and southern United States regions. See you tomorrow. Peace out, as they say in Canada. Oh, wait, do I have super chats? Let me check the super chats. Holy crap. Yes, Duncan Idaho. Sorry, Duncan Idaho says, "Is that a tuft of justice I see the judge developing?" Yeah, perhaps a little bit of tuft of justice. If it's a good judge, the tuft will always make them known. Yes, the tuft is always right. And Jinver, until today, I was unaware that you could Zoom via shortwave ham radio. Apparently you can, and apparently ham radio now has an optional video option to it. Let's go. Brandon says, if truth doesn't find you, Zelle and absinthe will. We read that already, so we're good. Terry with a $5. How can she claim anything? She can't even remember making the video. Oh yeah, she denied making the video. They're like, do you remember making a video on Sunday? No, I don't recall that. I didn't. Well, let's watch this. Oh, I throw up all the time. I'm sick. I don't want to watch the video. Do I have to? Yes. So yeah, she did claim that she doesn't remember making that video of him in the suitcase. Thank you, Terry, so much for that. And we, with that, are definitely, as soon as I get this off the screen, there we go. We are out. Bye, chat.